members. May I now request everyone to occupy the front round tables, please. Since it's a very limited audience, sir. Welcome to today's CPE State Circle series on Assessment Proceedings and Authority for Advanced Rulings by Shri Nitesh Dalmia. Before we proceed to the technical session, let us rise for IC mode. Thank you, members. Nitesh, he is a member of our institute, having more than 7 years of experience in tax consultancy, and he is presently working with PwC as a manager taxation. Over to the speaker.
Good evening, everyone. So, thank you, organizers, for giving me this opportunity to speak before you on this topic. So, today's topic will be assessment proceedings and advanced ruling. So, advanced ruling I'll be discussing on the procedures, sections, and I'll give you some practical examples about the difficulties or challenges which one may face before advanced ruling and some practical aspects about it. So, first we will deal with advanced ruling and then we will move to assessment proceedings. So, before getting into the provisions, if I had to communicate why this AR was constituted, what was the objective, and why do we really need it. So, to give you a perspective, in 1991, everybody knows that the Indian economy was opened for global investment. And to give comfort to the foreigners to invest in India, one thing was critical, that is to give them comfort around what will be the possible tax implications if they invest in India. So, advanced ruling was a platform which provided them an opportunity to understand what could be the potential tax impact on a proposed transaction and accordingly determine whether they want to do a particular business in India or not. So, that point of time, section 245N, I'll get you with provisions. But just to give you a perspective, 245N used to cover only non-residents who can file the application. There was no provision for residents to file the application, which came subsequently in 2014. So, either it should be non-resident approaching directly or it can be a resident approaching for a non-resident transaction. So, that was the objective. So, now, given that was the objective, what were the other benefits of approaching the AR? Other benefits of approaching the AR was it used to give you speedy settlement of issues. That is, you don't need to wait for AO to pick up your return, see the transaction, then you file an appeal with CIT and get all the way to ITET. So, if you file an application with AR, the intention was within 1 or 2 years you get a ruling which will give you enough comfort about the transaction. So, that is one, determining the tax liability. Second is bridging the difference between the opinion of the taxpayers and the authorities, because once you get a ruling, it is binding on both the taxpayers and the tax authorities in relation to the taxpayer and on the transaction for which you have applied the ruling. So that way there was a complete certainty as far as the transaction was concerned. And certainly it used to reduce the time gap in terms of the litigation time, which generally one see in India, wherein up to that stage of ITET, you take 7 to 8 years, and then you get some kind of certainty about the transition. So these were the basic objectives of getting into the AR. Now, to deal with the regulations, so provisions of AR are there in Chapter 19B of the Income Tax Act, which covers Section 245 and 245V. So we will discuss the main provisions. We will not go into the procedural aspect of it, which will not impact us on a day-to-day basis. So Section 245, this is the first section of the chapter. This is quite an interesting section because it defines the meaning of advance ruling and also specifies who can be the possible applicants for getting an advance ruling. Now, this is the unique section in the sense the definition of advance ruling changes with the nature of applicant. So, if it is a non-resident applicant, the definition of advance ruling will be different. If it is a resident applicant, the definition of advance ruling can be different. I'll explain you how is it. It also specifies who can be the possible applicants. That also we'll see in detail. So, I have divided the entire section 245N into this, so first is 245. So there is some typo error. It should be 245NA1. You can read 245N in between. So 245NA1, which deals with the meaning of advance ruling for a non-resident applicant. It says determination in relation to a transaction which has been undertaken or is proposed to be undertaken by a non-resident applicant. So if you read this carefully, it does not talk about determination of tax liability. It just says determination in relation to a transaction which has been undertaken. Determination again in relation to whom it is not saying. Is it determination in relation to the non-resident himself, or is it determination in relation to the transaction, or is it determination in relation to the other party with whom the transaction is being undertaken? That also is not being mentioned in this first subsection, if I have to say. So we'll see how to interpret this and what is the implication in the way it has been written, what can be the possible interpretation around it. Okay. Moving to the next, 245NA2, which is resident application, where the resident is entering into a transaction with a non-resident. So here, again, the determination of tax liability will be of non-resident if an application is filed under this subsection. Okay. Moving to the next, this is 245NA2A, resident application for its own tax liability. So this is the provision which I was talking about. In 2014, this subsection was inserted, and this allowed a assessee in India who is not dealing with any non-resident to approach to AR to determine the tax liability of a transaction which is more than 100 crore. So that was that came through a notification. So just for an example, what can be the possible scenarios where you can approach the AR? So you entered into a transaction with a party in India, say suppose purchase of IPs, and you want to understand whether these IPs are eligible for tax depreciation, and the transaction is, say, suppose of 500 crore. This is one transaction wherein you can approach the AR given your transaction value is more than 100 crore. So it does not say tax liability more than 100 crore. We should be mindful about it. So this is the third clause. Anybody who has got any doubt about the section, please feel free to ask in between. Now moving to the next, 245NA3, which is resident, but it only includes public sector company. It does not include other assessees. Now there is a special leeway to public sector companies. They can approach to the advance ruling authority even if their matter are pending before tax authorities, up to the level of income tax appellate tribunal. The last one here being 245NA4. Here both residents and non-resident can file an application before the AR, and the application will be to determine whether the transaction they are proposed to undertake will attract the provisions of GAR under Chapter 10A of the Income Tax Act. So unlike the first four clauses, the last one can only be done when the transaction is proposed. If you have done the transaction, you can't file an application for GAR before the advance ruling. Till here I'm clear? Yeah, please.
If the transaction is entered on 31/3/2017,
Okay.
like some amalgamation agreement application has been made, subsequently it has been approved in September like that.
Okay.
Whether GAR provisions will be applicable? The
So
application
that is, yeah.
before coming into.
So that's a different subject. That is applicability of GAR provisions.
If you want to approach the AR on this subject, since the transaction is initiated before GAR provision, but it is concluded after the introduction of GAR provision, on this ground can you approach the AR for?
My understanding is you can't approach because the transaction has been done. Although GAR provisions were not there in place, but since the transaction has been done, you cannot approach AAR. So if I read out the section for you, the section specifically says, a determination or decision by authority where the arrangement which is proposed to be undertaken by a person being a resident. So you should not just look into the applicability of GAR provisions as such, you should also see whether your transaction has been done. If your transaction has been done on the same transaction you are going to AR, AR may not entertain the application as such. That's my take on it. Yeah. Moving to the next. So there is a rule which is Rule 44E under the income tax rules. It prescribes the forms which has to be filed by various categories of the applicants for approaching the AR. So to simplify, Form 34C has been prescribed. In the first category, I'll just quickly take you to the first category of the applicant, which is 245 and A1, non-resident applicant. And it has been mentioned in a serial order. So first one is a non-resident applicant who has to determine the transaction. Yeah, so they don't need to. So I'll read out the provision. Determination by authority in relation to the transaction. So for them, Form 34C is applicable. Form 34D is for when resident is entering into transaction with the non-resident, and it is determination of tax liability in relation to the transaction. Third one is 34D, which is again a notified category of resident, which I told 100 crore and above transaction. Fourth one, 34E, which is specifically for public sector company, and last one being GAR. So while I have not mentioned the fees which has to be paid for getting the advance ruling, interestingly, the fees to get a ruling on a GAR application is only 10,000 rupees, which I find compared to other transactions to be very, very, nominal. Yeah. So what are the key points which one should consider while filing the application so that there are no defect notices issued after filing the application? So one should ensure first that he has picked up the right form for filing. There being 5 application forms. Second, you should enclose the POA of the person who is signing the application, and that should also be backed by an affidavit saying that the person is authorized to sign the application. Ensure that all the documents, so most of the time you will see AR being filed for the non-resident applicants. So all the documents which come from outside India, like certificate of incorporation, articles of association, or maybe charter documents of the company as per their local laws, this all should be apostilled or notarized or consularized as applicable. So it should not be just a certified true copy. Wherever it requires notarization, wherever it requires apostillization, it has to be done accordingly. Applications and annexures, oblique statements are duly signed, which I have already told. The other critical point is to understand, if it is a non-resident and I don't have a PAN, can I file an AR? The answer is yes, they can file an AR. If they don't have PAN also, but if you have PAN, you have to mention the jurisdictional assessing officer. And that can be found out through your area code and the corresponding commissioner details. Basis of claim for being non-resident. So this is critical. If you are saying you are non-resident, you should appropriately prove that you are non-resident, and that can be done with the help of a TRC and a certificate of incorporation. And nonetheless to say, they will not entertain any application which is not in the language which is other than English. So if it is in French, we should ensure that the underlying documents are converted into English and then file a certified copy of it. So these are the key points for filing the application. Section 245R of the chapter, it deals with the situations where AR will not entertain the application. Now, what are those situations, or what are those questions which AR does not entertain? One is when your question which you are asking in the application is already pending with the tax authorities. Tax authorities being assessing officer or appellate authority or a court. So if the question is pending before any of these authorities, AR will not entertain the application. Second is issues which is relating to determination of fair market value of the property. So we can't ask AR to determine the fair market value of the property. So I'll back up all these things with examples so that you get the provisions and the context very easily. And the last one being relates to a transaction or issue which is designed prima facie for the avoidance of income tax, which is nothing but GAR. Now if you observe this provision, there is some referencing errors, and that has been mentioned in bold. So erstwhile section 245NB had got different referencing of section 245NA. Now even after 245NB had got amended, section 245R has not been amended, and that is clearly reflected. They are referring to the old provisions only. So one should read this in line with the new provision. Ignoring it.
Companies can apply even if the question is pending before ITAC.
Yes, you are right. But one should ensure that they can't file when the matter is pending with the court. So so that is also clarified with the help of a circular. I will take those examples for the benefit of all. And one should also understand that AR does not reject an application without granting an opportunity of being heard. So that is given. Till now, I'm everybody with me, or if you need anything which I need to explain again, I can explain it. So, but what is the timeline? So it's very visible on the slide. What is the timeline to get a ruling from AR? The timeline is 6 months as per the regulation. Now the question is, practically we don't see any order coming within 6 months, not even admission happens within 6 months. So is it recommendatory or directory? So the handbook on AR clearly specifies that this is only recommendatory. They endeavor to do this within 6 months. It may not practically so happen within 6 months. This is a very interesting session. I don't know whether anybody would have used this section in favor of their client. This is 245RR. It says, where an application is filed by a resident applicant, the tax authorities cannot touch that transaction till the time the matter is pending with the AR. Tax authorities here will be the normal assessing officers to the level of appellate tribunal. So, just to give an example, I, being an Indian company, getting into a transaction with a non-resident, I believe that if I don't withhold taxes, I'll be penalized. While the non-resident believe I don't need to withhold taxes. Non-resident approaches AR to get a ruling whether this transaction is liable for tax in India. I, being a resident, I don't approach because I'm thinking that matter is already being changed, asked by the non-resident. Why should I again file an application? In that case, your AO can initiate proceedings under section 201 and can make you liable for tax withholding and can make you a assessee in default for not withholding taxes. To safeguard myself, I can do one thing. I can ask the non-resident, see, if the tax authorities challenges this transaction, I face the risk of penalty, interest, tax expenditure disallowances. So let me also file an application. The questions and the facts will remain the same, just that I, being an applicant, I can take benefit of this section 245RR, and till the time the matter is pending with AR, nobody can touch my transaction. So that way I am benefited by using this provision. Anybody who want me to explain this again? Because
what will happen if the assessment is getting time barred because if AR doesn't deliver within the time limit? Suppose will the period of AR will be excluded, there is no specific provision for that. Because if it is going to be time barred for the assessing officer to make the assessment either in 202 or probably in 40 only.
I think 153 provides an exclusion for this if the matter is pending with the AR. So that way, if the AR is against you at the end of the day, he can reopen to that extent and do the adjustment.
So for a particular transaction, then a non-resident will also apply and a resident will also apply. So
Absolutely.
on the same transaction, We
Absolutely.
cannot add as a party to it. We can just have to file a different application.
Because-
but that will involve fees, right?
Absolutely. So that will be your negotiation with the non-resident, that expenses arising from this transition you have to bear it. Because it is a non-resident who wants you to take an aggressive position. So yeah, but the best thing for you being conservative, you will withhold taxes. If you are not withholding taxes and favoring the non-resident, they should also favor back to you in terms of bringing the, taking the cost of expenses. So this benefit is to all residents. It does not discriminate between which category of applicant you are. So they refer to 245Q, which is applicant filing the application. Yeah.
Suppose the assessing officer has issued 142(1) notice, but it's not initiated any other proceedings. Can it go for advance?
I've covered all those questions, so just give me 2 minutes. You will see those questions. Till now, everybody with me? Yeah. So these are the last few sections which I have discussed, 245S and 245T. 245S says the advance ruling pronounced by an authority shall be binding only on, which I have already told, on the applicant who has sought it, in respect of the transition in relation to which the ruling has been sought, and on the principal commissioner or commissioner and the income tax authority subordinate to him in respect of the applicant and the said transition. So to summarize, in relation to the transition, the applicant and the tax authorities who are dealing with the applicant. It will be binding only on them. It can't be binding even though the tax officer in that jurisdiction is dealing with the same transaction with another assessee or a group company of yours which has similar transaction. It won't be binding on those transactions. It has to be binding only on the assessee. So if there is a change in the law or fact, assuming the law changes with retrospective effect, AAR can modify its order. So there is a provision under AAR rules which helps the AAR to modify the order if there is a change in the law. Needless to say, if the ruling has been obtained by fraud or misrepresentation, that ruling is nullity, and AAR will pass an order nullifying the order. Now with this we'll get into the questions answer mode. So what all possible situation in relation to the procedure and section itself which we can think of, I've tried to jot down in this question so that you can relate this question with the provisions. First one being, if a non-resident applicant should compulsorily seek a ruling before the AAR in regards to its own tax liability. Now this is very interesting. I will first take you back to the provision. Yeah. So first line, if you see, for a non-resident applicant, what is the meaning of advance ruling? Meaning of advance ruling is determination in relation to the transaction. It is neither talking about the tax liability of non-resident himself, correct? Even for the time being, one can assume it can even include will tax. I'll clarify that also. So when this provision itself is so broad, it is not restricting that your question should be in relation to the tax liability of the non-resident. And non-resident for whom the tax liability of another party is critical while taking a decision, those questions can also be asked by the non-resident. And this has been done. I'll give you the case law where this was tested, and AR told that in this situation, the non-resident can apply for the ruling even though it relates to the tax liability of the other party. So what happened in this case, Umicore Finance, here what happened, the non-resident investor wanted to purchase the shares of an Indian company. This Indian company was created by way of conversion of a firm into company. Now, whether this conversion of firm into company will attract tax liability or not, that was the question in the mind of the non-resident, because that will determine his purchase consideration. If there is a tax liability, the overall consideration value will reduce. So to do this, and before undertaking the transaction, the non-resident approached the AR to determine the tax liability on the previous conversion of the firm into the company. And AR said this application is maintainable because it is critical for him to make an investment decision. And if you go back to the background which I have given, AR was created only to facilitate non-residents to make investments in India. So that keeping those broad principles in mind, AR held that this application is maintainable and they admitted the application. What happened subsequently is a different matter. So this is one which you can relate now to the section itself. Second, is the residential status of non-resident individual applicant needs to be seen on the date of the application. So this is again a very tricky and interesting situation. Now assuming there is a non-resident individual, he has come to India in the month of July and he believes that he will be working in India for more than 182 days in this year for the purpose of his business or for exploring the businesses in India. Now if he wants to approach AR for any transaction to get tax liability or determination of tax liability on any transaction, how will his residential status be seen? In July he would have covered only 30 days, but he don't know whether he's going to stay for 182 days in that year. If I see the previous financial year, he was never there in India. While filing the application, his status may change in the process of the application and subsequent admission. His status may change. So what should be the practical answer to this? So AR in one of the decision has held that in case of a non-resident individual who approaches the AAR, his residential status has to be seen on the basis of the previous financial year and not the same year in which he is filing the application. So this is a unique judgment in the case of Monte Harris, and where the individual was a resident, and as per his residential status, previous financial year he was not a non-resident. And what is the principle conveyed here is this provision of the entire chapter 19B is open to the non-residents who wants to do business in India, and even if subsequently while discovering businesses in India you become resident in the financial year in which you want to file application, you can still approach the AR considering your previous year status. Moving to the next. So this, I think I made it very clear whether a public sector company can file an application before AR if the matter is pending before High Court. It's not, tax authority is not ITAT. So the answer is no, and this has also been clarified by CBDT circular number 794 dated 9th August 2000. If an application filed with AR can be withdrawn after filing, it can be, okay. What is the timeline in that case? Is there any timeline prescribed? So there is a timeline prescribed under section 245Q, subsection 3. It says application filed with AR can be withdrawn within 30 days of the application. But practically AR had allowed withdrawal of application even beyond 30 days. And there again we have a precedent, which is Manfred Store. I don't know how to read this. It's a foreign company. So in this case, the application was for more than 30 days and AR allowed to withdraw it. And the reason why AR allowed to withdraw it is because it mostly goes to the fact that there was a lot of pendency in AR at this point of time. AR also wanted to clean up their files, so they allowed to withdraw it. And this is also there in the FAQs, in the handbook of AR. If questions raised in the application can be considered to be pending if the assessee files its return of income. So I think you asked about 142.1. We'll get there. This is the first step. So if you file the return of income, whether your matter can be considered to be pending before the tax authorities. So there were so many judgments, both for and against, till the time this issue has been settled to rest by Supreme Court. In the case of Sin Oceanic Shipping, Supreme Court held that where the income tax return was filed before the filing of AR, till the time 143.2 notice is not issued on the return, it cannot be considered to be pending. Any 143.2 notice issued after filing of the AR application does not impact the AR application. Any questions till now? So we'll move to the next slide. This slide has mostly questions in it. If generation of 143.1 amounts to pendency of application, so there can be a debate, but the possible answer should be no, because 143.1, if I go by the current trend, it is done by CPC in Bangalore. Nobody applies their mind on that. It is computer generated intubation. So it is not pending with AO technically. If it is not pending with AO, it is maintainable. If application can be filed after receipt of assessment order, this is very, very tricky. So what is considered as pending before AO? If the assessment order has come and I have not filed any appeal with CIT appeals, or for that matter assume DRP, it's a draft order, can I consider this as pending before AO? So answer will vary. If it is a draft order, it can be considered as pending before the AO because the assessment is not yet concluded. In that case, you may not be able to file AR. But if the assessment order is passed and you have chose not to file an appeal, it is not pending with the AO, and hence you can file an AR application on the transaction. So practically, people have done it in the consultancy. If an application can be filed where assessment is initiated, but the question before the AR is not questioned in the assessment notice, which is effectively 142.1 notice. So this answer to this should be no, because while that same question would not have been asked, but the entire assessment is now open in the file of AO. So my understanding of this is the AR application here may not be maintainable because the assessment is open and all the issues are lying in front of AO. It is just a matter of time whether you can pick it up or not. It's a different issue. So does that answer your query?
So it's not approach to us.
That's my take on it, yes. If you have got the 142.1 notice, because in that case assessment is open and I don't think there are any favorable jurisprudence on this. There can be views, but not a judicial entity.
If the assessing officer has proceeded a directive to 142.1 without 143.2,
Then it is then assessment itself is not valid. So if the assessment itself is not valid, it is not pending. But you have to first challenge the assessment itself, then go to AR. Before challenging, if you go, then it may be a problem. Yeah. With this, we'll move to the next. So this is again very tricky. Similar to the question which I asked. If the assessment order is passed, I want to file an appeal, but I have 30 days time with me. In this 30 days time, the matter is not pending with AO also, neither with CIT appeals, since I have not filed the appeal. In between, if I can file an application before AR, and then subsequently file an appeal with CIT appeals, because what you have to see is on the date of filing application, the matter should not be pending. So here there is no concrete answer. There can be debate. Most likely AR may not take it very positively, and they will say you are trying to touch two different forums for the same matter, which is certainly not allowed. Yeah, so anybody had ever any experience of ex parte order in relation to AR maybe? So first let me tell for the benefit of all what is an ex parte order. So where an applicant has filed application but has not represented the case on the date of hearing, AR can pass an ex parte order, that is without the party being available on record, they pass the order. Now the order can be both negative as well as positive. Most likely, given there is no representation, it is likely to be negative. So what is the solution to the applicant if such an order is passed? So AR rule 17 says once you receive an ex parte order, you should make a representation to the AR within 15 days of the receipt of the ex parte order, requesting AR to withdraw the order and explain the reasons why there has been why the case was not represented on the date of hearing. So if this is done, AR may withdraw the order and freshly hear the application again. If a ruling pronounced by AR can be modified or rectified, I think I answered this at the beginning itself. If there is a change in law retrospectively, or there is some wrong facts applied at the time of giving ruling, in those situations, AR rules allow AR to modify the ruling. So Rule 18 and 19 allows the AR. There is one condition to this modification, that the effect of the AR order should not be given by the AO. If the effect has been given, then it is possible that the modification may not be possible. Now this can again be a point, because what is the meaning of effect? If the transition has not happened, assuming it is for a prospective transition, most likely effect would not have been given, and hence there can be modification. Effect can only be in those situations where you have done the transition, paid the tax liability, AO has also passed the order, and then there is a change. If questions related to transfer pricing can be posed before the AR. So transfer pricing will essentially involve determination of the fair, arm's length price, which is akin to valuation. Correct. So seems like your view is it should not be applicable, right? So that is correct. AR application is not maintainable on the determination of arm's length price, but with regard to applicability of the transfer pricing provisions, one can ask this question. If an appeal can be filed with the High Court against the order of AR? Yes. Anybody who has a no answer here? If an appeal can be filed with the High Court against the order of AR? Or everybody is yes? So the answer is no, and I will explain that how it is no. So the ruling of AR is binding on the assessee, on the transaction, and the tax authorities. There is no provision under the Income Tax Act to allow you an appeal against the order of AR. What you can do is you can file a writ with the High Court. So appeal is not possible, but you can file a writ. If a transaction is pending or disputed by the tax authority, can a similar transaction be taken before AR for adjudication for another year? So I'll give you an example. So if you have done a slum sale transaction in, say, suppose 2005, the file has been picked up by the AO. He has disputed a tax liability on the transaction, various intangibles he generated from the transaction. He disallowed the depreciation on the intangibles, and those whole story is over, and matter is right now pending with ITAT, for an example. Now you again undertake similar transaction in 2017, and you want to get a ruling from AR on a similar transaction of slum sale. Can you do it? Is the question. Yeah. So the answer is yes, it is possible. Yeah, because the AR ruling is on the transaction. So that transaction which is in dispute, you are not approaching for that. You are
transaction, but similar.
correct. So you are approaching for a different transaction. It is very much maintainable, and practically people have done it. This is the ruling which gives it some precedent value that application is possible in this situation. Moving to next. If advance ruling can be obtained by a foreign company where an Indian company is bearing the tax liability of the non-resident. So it's like a gross-up situation. Gross-up situation will be for the benefit of all. If I am the payer and a non-resident is a payee, I say to the payer that whatever tax liability arises from the transaction, I will bear it. So the question is, if Indian company is bearing it, why should a non-resident apply for a ruling? Take an example of a fees for technical services or a royalty transaction. So the answer to this is yes, the non-resident can approach, because still
He's liable.
is liable. Yes, you are right. Maybe
Liable for the tax payment, but here it is borne by the.
correct. So since he is liable, he has to file a return of income also, and there can be further disputes by the tax authorities. It can be on the rate, it can be on the application of treaty,
Because and
whatever.
further, the Act doesn't say that, it says the transaction, doesn't anyway specify about the tax liability, whether for
Correct.
the non-resident.
So that's the 245 NA1. It says the transaction.
Determination of tax liability. For
Absolutely. So non-resident has to or should file if they want to file. So this concludes the discussion with regard to AAR. If anybody has any doubt, please feel free to ask. We have enough time.
Suppose a non-resident company has applied for, say for FTS, they've applied for the advanced ruling, and the resident company which has to deduct tax on that, it's two separate applicants. So the resident has not applied for the same transaction. In that case, the AO for that non-resident, he will it is pending before the AR, so it will not be the order is binding on the AO. Right.
So when the matter is pending before the AR,
yeah,
for the non-resident,
but the resident has not applied to the AR on the same issue.
okay.
Whether 201 proceeding can be initiated for this resident since he has not applied.
No, I'll answer your no. In fact, I see two questions in your answer. What you have asked me. One is, once the non-resident has filed an application, what you believe that AO will not touch his side of the transaction. 245 RR does not give a benefit to the non-resident. So the tax officer can still touch his side of the transaction as well. Now when it comes to resident, you are right, the assessing officer can initiate 201 proceedings because the resident has not approached the AR. It is the non-resident which has approached the AR. And technically if you think a non-resident which does not have any presence or any offices in India, technically their PAN number will be of Delhi, correct? And the CIT or the officer will also belong to Delhi. For the resident, it can be Delhi, it can be Chennai, it can be Bangalore. So the CIT will also be different for both the non-resident and the resident. So how can something which is binding for a CIT of Delhi will become automatically binding for a CIT or tax officer of Bangalore or Chennai? So that way it can always be subject to dispute by
Even
the...
if the ruling is in favor of the...
If the ruling is in favor, then nothing to do. Then it is done. But if the matter is pending, at that point of time it can be
If
touched.
the ruling is favor of the non-resident, whether the resident can quote that and say this is the reason why I have not deducted.
So most of the time when a non-resident approach for the tax liability of his own, he will also pose a question about the tax withholding liability at the end of the application. Or I will say the questions framed for the ruling. So he will certainly ask, if it is not liable for tax, will a resident liable to pay tax, will withhold taxes? And to answer you, we have Supreme Court judgments which says if the non-resident is not liable for tax, you are not supposed to withhold taxes also. Just to quote G India Technology, which is the Supreme Court judgment on this. So if it is a favorable ruling which says it is not liable for tax, certainly you can use it and say you're not supposed to withhold taxes also.
The order is unfavorable to us. See the writ jurisdiction is available.
Certainly,
For the
yes.
department it is not available.
Department also it is available.
Okay.
It is
They
available.
go on writ under the
Yeah, so
this jurisdiction, is it available to the government?
yes, it is very much. So you will see those rulings where AR has given a favorable ruling and department has already approached several high courts as well as the matter has travelled sometimes to Supreme Court also. So writ is applicable for them also, yes, yes. Any questions on AR?
There is no threshold, that is for non-residents, there is no monetary threshold for application. Right?
There is no monetary threshold, yes. So monetary threshold is only in a case of
For resident,
245 and 2A.
100.
Should we proceed? Yeah. So assessment proceedings, what the topics which we are going to discuss here is, we have covered it broadly. What we have not covered is assessment proceedings in case of search or procedure in case of search and seizure, and for that matter survey. So that is not covered here. Rest all I have tried to cover here so that to give perspective about the provisions. So if somebody can volunteer and say what is assessment in a very layman term, what is the meaning and what is the objective? Okay, so I'll explain that. So assessment, we keep anyways dealing with the income tax department on the assessment. So objective of assessment is to determine the tax liability, whether the assessee has appropriately computed his income or loss and have discharged tax liability on it, whether he has been underpaying taxes. That's the whole objective of the assessment from the income tax department perspective. So when we know the assessment, we should understand what is the beginning of the assessment to commence. When does the assessment proceedings commence? So assessment proceeding commence once we file the return of income in India. So moment you file return, your assessment can be taken up. Now these are the kind of returns which can be filed. One is mandatory or voluntary return, which is 139(1), loss return 139(3), belated return 139(4), revised return 5, and defective return is 9. Yeah. So how these are different, I'll try and explain that. So while 139(1) is filing of return is compulsory for a company and a firm assessee, whether or not you have any tax liability in India. So this is something which is very basic. Loss return, why it is important? If you want to carry forward and set off your losses, it is important for you to file 139(3) return. 139(3) relates back to 139(1), so it is as good as return filed under section 139(1). Belated return is something which you don't file within the time limit under 139(1) or 3, so the return file becomes belated. Moment it becomes belated, what are the repercussions of that, we will discuss. Or let me discuss it right across. So if you don't file a return within 139(1), what can be the possible implications? Any? Loss does not get carried forward, right?
You have, if there is a tax liability was not paid, then you have for A interest.
Absolutely, interest liability.
Now you have a fee also for belated.
Yeah, so that is very interesting. I want to discuss that more. What is that fee? Yeah, please, you're saying something.
And certain deductions are not available.
Correct, which is 10A and Chapter 6A.
Chapter 6.
Yes. So
The right of revision is also restricted sometimes.
that is now changed. So I'll discuss that also. So the point which ma'am told that you will have a penalty. Now they have termed it as fee. Yeah. So that is now 234F, which was earlier 271F. Yeah. So 271F, which was again the penalty of 5,000 for not filing the return within the assessment year. Now that provision has been deleted from that, and instead of that, this new provision, which is 234F, has been introduced. What is the objective and implication of it? Earlier, although it's a very small amount, but there is right now a writ filed in the Madras High Court against this section. And what are the interesting points covered in the writ? I'll just, for the benefit of all, I'll say. So one is, they have termed this as fees. Fees corresponds to services. Where are the services here? So to challenge the section, they are saying, why should it be termed as fee in the first place? It is not a fee. Other point which they are saying is, the amount of penalty is similar for all assessees, even if it is 1 crore to the extent of 5 lakhs. So below 5 lakhs, they have reduced the penalty amount to 1,000 rupees. So that is very meager amount, and you are covering all the assessee within the range of 5 lakh to 1 crore or maybe hundreds of crores with the same amount of penalty. Earlier there was section 273B, section is still there, but 273B used to give powers to AO to waive the penalty under section 271F if there was a genuine reason for the default. Now given this 271F is no more there in the picture, what you have is 234F, which is not covered under 273B. The penalty or the fees which they are terming is automatic. So earlier you had a chance to say and convince the officer there should not be any penalty. Now the quantum of penalty also is different. If you have delayed beyond 31st December, the fees is 10,000. If it is you are filing after due date but before December, it is 5,000. And if your case is less than 5 lakh, your penalty is restricted to 1,000. So you have given various categories also, which is again does not seem justifiable. If you have to leave a penalty, you should leave a penalty. There should not be slabs in it. So these are the basic points which has been covered in the writ before the Madras High Court. I don't recall the name of the writ, but just for the knowledge of all. So moving forward, defective return, as you all know, when there is something missing in your tax return which does not make it illegal, or I will say it does not make it null and void, AO or the tax department has to give you an opportunity to rectify those defects within 15 days of the communication of notice, and that is if the defect is rectified, the revised or rectified return will relate back to the original return. It can be a 139.1 return or it can be 104 return, any which ways. So anybody has recently dealt with a defective return problem where even after rectifying the defect or mentioning the reason that there is no defect, still one more processing has been done and they are saying there is a defect and you should again revise it. So this mostly happens in the case of a non-resident assessee where they want to claim tax refunds and they don't want to offer any income, so they will not put any income in the income part of the ITR, and the return processing will keep throwing up defects saying that you have not mentioned the corresponding income, you are claiming credit of taxes. So I have particularly encountered this situation. So we went ahead and made 2 further complaints with 2 different forums. One is CP Gram and one is E-Nivaran. So although it didn't help us much, but for at least our comfort, we did it for the comfort of saying that we have done enough. Now it is for the department to do it. So these are the 2 forums. Beside doing a normal rectification of the return, you can also approach these 2 forums, place your query and the problem and ask for a solution of this. These are the due dates. So I'm not going to discuss it much. I think this is very basic. Verification, we generally we know the head of that particular firm or company generally should file return of income. So if it is HUF, it is Karta who is the head, he should file. If it is firm managing partner, if it is company managing director, if there is no managing director, then a director. Similarly for LLP, it has to be designated partner. If there is no designated partner, which is not possible, but if it is for the time being it is not there, the partner can also file. So these are the various categories of person who should sign the return of income. Yeah, so we already discussed belated return. We didn't discuss, okay, so we discussed the sections also, right? So consequences of belated return we have discussed. Now moving to next. Can depreciation be claimed in case of a belated return? Which is yes. Condonation of belated return. So this is very interesting. So what is the recourse available to an assessee who has, assuming for an instance, 60 lakh of losses to carry forward, so, and they didn't file a return within time, 139.1 or 129.3. What is the recourse? What can they do?
Possibility.
Perfect. So they can approach CBT under section 119, and there is a circular which enables the assessee to file. Now they have given 3 categories. So if your loss is less than 10 lakhs, you can approach principal commissioner or commissioner. If your loss or refund, so sometimes you may forget your refund claims also, and maybe a foreign company which has refund claims, they were not aware they can file returns, and you suddenly realize, okay, as an advisor you realize, okay, you can file return and claim refund for those years. So the time limit here is 6 years from the end of the assessment year to which the return relates. You can approach these authorities as per the circular for giving you relief. So time limit is 6 years, and they should dispose the application within 6 months from the end of the month in which you file the application. Now 3 categories of the authorities. One is principal commissioner or commissioner, which is for up to 10 lakhs. 10 to 15 lakhs, principal chief commissioner or chief commissioner. And the last category being CBDT. So if it is beyond 50 lakhs, you have to approach only CBDT. eligibility to of loss carry forward in case of a revised return. So in case of a revised return, can loss be carried forward? The answer is yes. So under what circumstances a return can be revised? So this can be debated by the tax authorities. What circumstances can trigger a revision? Anybody wants to challenge? Discuss and maybe share your experience. So when there is any omission or error in the return, you can file a revised return. So then there can be a question, okay, can you make a fresh claim in the revised return? Till the time you are able to prove there is an omission.
Because of omission.
Correct. Now can the return be revised after summary assessment? The summary assessment is 143.1. Can it be revised after that? Yeah. So return can be revised till the time the assessment is completed or time limit for revision has not elapsed, whichever is earlier. The way forward against a 143.1 notice, if you have some tax payable or your loss has been reduced or some allowance has not been granted, what can you do for that?
154 I can go on appeal also before the commissioner.
Perfect. So you can do both. You can file 154 and you can also approach the commissioner. Inquiry before assessment 142.1. So most of us in the assessment proceedings we deal with this 142.1 notice. This notice may have two objectives. It may ask you to file a return of income where you have not filed the return, or it can ask you to furnish certain documentation which the assessing officer would like to see. Now there is no, okay, so instead of jumping, let me move to the next point. Notice issued for ascertaining income or loss of whom? So can a notice be issued to company X to give details of company Y, assuming company Y is subsidiary of company X? Can a notice under 142.1 be issued to company X to give details of company Y, which is its subsidiary? The answer is yes. It can be issued to a group company to give details of the other company also. Eligibility to carry forward losses for return filed pursuant to 142.1 notice.
Come under one, they can issue under 133.
They can certainly do it, but AO may, so as a assessee, if you go and represent before AO and they know it is a group company of yours, he can similarly ask you details for those companies. So eligibility to carry forward losses. Now given 142.1 gives you an opportunity to file a return, whether that gives you an opportunity to claim carry forward of losses which you may otherwise not get because it's a belated return for you. You have not filed it within time. So 142.1 does not regularize your losses. So it does not give you an opportunity to carry forward your losses. Technically under 142.1, as per the provision, the officer cannot ask the financials or financial details for more than 3 years. So to the second last question, if the accounts beyond 3 financial years is sought for in the 142.1, you can always make a submission that the power given under 142.1 is to ask for details up to 3 years. This year is not valid. What can be the possible consequences for non-compliance if you don't comply with the 142.1 notice? Sorry? 271? Okay.
But without filing, you can't issue 141. So 271D can be.
271.1D is that the section? I understand you want to convey penalty section. The correct section is 276D. Okay, that is the section which levies penalty on you if you don't comply to 142.1 notice.
Will come under prosecution. 276.
Okay, so you're talking about prosecution. Yes, so prosecution can also be done if you don't comply with a 142.1 notice. Other is best judgment. Yes, so the best judgment assessment can also be done on the basis of whatever information is available with the AO.
One assessing officer.
For the purpose of AR, you are saying? So if 142.1 notice has been issued and you are saying you have not complied with the notice till now.
No, not time, sir. What I'm trying to say is the 142 notice is issued to file a return.
Perfect.
You have said we have already filed like that.
If you have already filed.
Yes, we have already filed.
Hmm.
So we have implemented accordingly, we have already filed. Treat that return as return filed under section 142.1.
Perfect.
Whether this will be treated as assessment pending before the assessment assessing officer?
So if 142.1 has been issued to you without any assessment in place,
Yes.
you can, I think, file an application with AR if you are planning to file, because assessment is not open, be it a 143.3 or be it a 148. So if that being the case, I think AR application is maintainable here. But if 142.1 has been issued during the course of assessment, that is after issue of 143.2 and for getting further details,
Inquiries.
then certainly the answer should be no. So I hope that is convincing. Yeah, perfect. Just a second. Yeah, so now we move on to 143.2. So what is the requirement under 143.2? What is 143.2 first? So 143.2 is the notice for doing the assessment, which is your regular assessment. Correct? Now, the time limit for 143.2 is 6 months from the end of the financial year in which the return is filed. Okay. Now, 6 months for what? Is it for issue or is it for service? It's for service, correct? Now, if you are saying service, so if I, as a AO, if I put the notice with the postal authorities, say suppose speed post, will it amount to service? So service mean you should get it in physical form or maybe electronic form. So you are right, it has to be served on the assessee.
147 it is issuance.
Correct. Correct. So most of the sections will talk about issue. There are very few sections which will talk about service. This being one. Can 143 notice be served if no return is filed? So the pre-requirement for issue of 143 notice is to file return. So without a return, be it a 139.1 return or be it a 142.1 return, or return in reply to the notice under 148. There has to be a return in place to get a 142 notice. Timeline I have already told. Notice issued after timeline not curable. After timeline not curable defect under section 292 BB. So 292 BB. Okay, so I can't produce the section on a presentation here. So 292 BB says, I'll just read it out for the benefit of all. It says, where an assessee has appeared in any proceedings or cooperated in any inquiry relating to an assessment or reassessment, it shall be deemed that the notice under any provision of this act, which is required to be served upon him, has been duly served upon him in time in accordance with the provisions of this act, and such assessee shall be precluded from raising any objection in any proceedings or inquiry under this act, that the notice was not served upon him on time, served upon him in an improper manner. So 292 BB, it says that if the act requires service of notice, and even though the service was not proper and you have cooperated with the tax department, then you subsequently cannot raise an objection on service. But section does not say about issue. So if the issue is not proper, you can still challenge it even though 192B raises a bar on it. So in our example, under a 143.2 notice context, if the notice was issued after 6 months from the end of the financial year, in that case you can still challenge it. Under 292 BB, saying that 292 BB does not cover it, even if I have cooperated and have answered you or given a reply to it, I can still challenge the proceedings.
Normally, if the address gets changed, the SSC does not intimate to the department. So in in such cases, how the service will be?
So in that case, if the notice is given on the same address, the old address, it is not service effectively. So one can challenge on that ground, but at the same time, it is the duty of the assessee to intimate the tax department that there is a change in address. So either ways. Generally, you take a practical call also. Sorry.
If it is electronically served, then
Correct. So 282 section has been amended, which says how the notices has to be issued. So issue is putting the notice in the digital platform or sending it through digital platform is also a proper issue. So when you are saying it is issued through those platforms, those are also valid service or issue. Assessment without 143.2 notice, I think we have already discussed that assessment is nullity and you can always challenge it. Consequences of non-compliance, again you can have a best judgment assessment here. So this is a small, comparison between a 143.2 notice and a 142.1 notice. One major distinction which I think we have not discussed is under 142.1 notice, the tax officer can ask you to give the details in the way he wants. So if we ask you, yeah, please.
So in the previous slide, suppose if you not even file a return, still 148 notice can be issued.
142, 143.2?
8 can be issued, right?
Yes, that can be done, yes. So the procedure is you get a 148 notice. If you have never filed a return, then you will have to file a return. And once you file a return, then a 143.2 notice will be issued. Yeah, so I think most of it we have discussed. Subject to the approval part, that 142.1 requires the officer to get an approval from Joint Commissioner if the statement of assets and liabilities not included in the accounts have been directed to be submitted by the officer. So if they require something which is not included in your financials, he should get an approval from the Joint Commissioner to send such notice to assessee. And there is no restriction under 143.2 with regard to getting the details for more than 3 years, which is there under 142.1. Any questions till now? Now we will discuss in detail about scrutiny assessment. So we all would have seen some cases of limited assessment. So limited assessment is nothing but all these computer generated notices which follows a protocol of picking up the cases on the basis of some kind of expenditure claim or excessive expenditure in a particular year or excessive income or for that matter any new allowance. So if those are the cases, the computer may automatically pick up some cases and these are called limited assessment. Here the scope of inquiry for the assessing officer would be limited to the reasons picked up by CAS, which is computer aided assessment system. Complete assessment is where the assessment is open to AO. He can ask any question with regard to that return of income. So it is not, he is not bound to go by the CAS reason or something. So limited assessment, practically AO has, if a assessing officer wants to convert a limited assessment into a complete assessment, he has to record the reasons why he believed there can be an under assessment of income or under assessment of tax liability in this particular case, and hence he want to move it to a complete assessment. And technically, if a limited assessment is converted into a complete assessment, the assessee can also ask the tax officer to provide those reasons. If the assessing officer says he is not willing to share those reasons, you can challenge it by way of a writ before the High Court. So this is something now will look akin to a 148 situation, where he has to record his satisfaction and those satisfaction has to be shared with the assessee.
but is it not somewhat routinely done?
It is routinely done, but if the assessee is very critical and he is not willing to share those details, or he you are very law specific. So most of the time you see SSE cooperating, okay, you want details, I'll provide so that my other years are also not impacted. But technically one can challenge this. Something?
Can we challenge during the proceedings itself? Now the case has been picked up under cause that computer scrutiny.
Okay.
Later on, he converted into for physical scrutiny and pass order with respect to the matters not covered under that ceremony.
Perfect.
Can we challenge that one?
So moment he asks you some details which is beyond the CAS reasons, because first notice which you will receive, it will say very specifically it's a limited scrutiny. And if he is asking something beyond the points covered in the limited scrutiny questionnaire, you can ask the question AO immediately, show me the reasons why do you believe there can be an underassessment. If he does not provide you the reason and still go ahead with the assessment, certainly you can challenge that order before the High Court. So you have to ask. First thing is you have to ask the reasons and you have to communicate to the assessing officer that if you proceed without providing those reasons, the assessment is not valid.
Can we take up this standard before the appeal level, CDF?
It starts now, the assessment is complete, he accepts that and goes to the assessment. After the assessment is completed, can he go back?
So if assessment should be ideally get completed, because if you challenge, it is not necessary that he will wait for you. He may dispose the objection summarily, or he may give some reasons and still close the assessment.
If they cooperate, then it will.
If you cooperate and don't challenge it, then I believe then then it may be difficult for you to challenge it subsequently because you have cooperated it. But what is the exact legal call on it? In fact, I am also not sure. So if you have cooperated and still you want to challenge, I think one can explore it, because if it is not a valid assessment altogether, even though you have cooperated, and it is not a bar under section 292 BB, it is not getting covered under those bars. So one can still explore those situations.
Somewhere during the assessment proceedings, you should have raised it with the assessing officer, or you can raise it as a fresh issue
After the order, that's what. So ideally you should challenge it at the time of assessment itself. If you have not challenged and you want to challenge it for the first time with the appellate authorities, my view is one can explore it.
CIT permission is also required, isn't it, sir?
Sorry?
For expanding the scope of scrutiny, he needs to get the AO has to get the
Correct.
CIT approval.
Correct. He has to get the approval of joint commissioner.
And some monetary limit is also fixed, I believe.
Correct. You are right. So the monetary limit for a metropolitan related assessment is 10 lakhs. If it is non-metro cases, it is 5 lakhs.
Would we file an RTA application for getting that?
Reasons. So ideally, it is your own information. If you file a submission asking for those reasons, he should share it with you. If he has never shared and went ahead with the assessment, then you are left with that option only, RTA. So principle of so when can a limited be converted into a complete scrutiny? We have already discussed. Principle of natural justice and principle of consistency, which is generally which is also called as res judicata. So natural justice is different. Principle of consistency is res judicata. So most of us would have heard about this term, res judicata, which says res judicata does not apply to income tax proceedings. That assessing officer is not duty bound to follow what has been done in the last year. He can make different. He can take different position. He can make different, amendments or different additions in the orders. Natural justice has to be followed. Natural justice means you have to give the assessee to represent his case opportunity to make him heard.
The certificate is equally applicable to the assessee also. The last assessment probably I would have accepted, not gone for an appeal. That does not preclude me for
Absolutely. Yeah. So evidence. So here evidence means your assessment is going on, and assessing officer issues a 133(6) notice to one of your vendor or maybe a debtor, and he gets some details from them. Whether assessing officer should share those details with the assessee before taking any position on the basis of those details shared, which is nothing but
principles of that.
I can also ask for cross-examination.
Absolutely. So now I'm dealing with the next point, which is evidence. So yes, assessee should be given an opportunity to cross-examine those details and file counters if it is required. So the law of evidence, which says the other party should be given an opportunity, has to be given. Fresh claim during assessment. Can I make a fresh claim? I didn't make any claim under 10 AA for an example, and I want to make a fresh claim, assuming there is no restrictions under other sections which allow me, to file to go get those claims only in the return of income. So this is more or less settled issue. Correct. So it's already written there. Goze is applicable, which says if you want to make a fresh claim before the assessing officer, you have to do it by way of a revised return if the time limit is there. If there is no time limit, those fresh claim cannot be made with the assessing officer. So what is the solution in that case?
Appellate authorities.
Perfect. You have to file it before the appellate authorities. But we have to ensure that at least we file a claim before the assessing officer, let him reject. It will form part of the order, and then we can make it before the appellate authorities. Even though it has not been done, and we know the assessee got enlightenment only after the assessment order is passed, and somewhere your matter is pending before ITET, and you want to make a fresh claim, still you can do it.
But there is a very old circular which says it is the duty of the assessing officer to
Correct.
provide all the
You are
opportunity exemption which is available.
Correct.
And they now rely on God's India and reject all these things.
Correct. So what you are talking is some circular issued in 1955.
Yeah, exactly.
So very old circular number 10 of 1955.
In one case, we failed to claim the dividend income as exempt on section 1034.
Oh, okay.
Since we have not claimed, they are ready to give.
Oh, practically you are looking at this situation. So I think you can very well rely on the circular which Saras told.
It is exemption, not even a direction.
Correct. It is an exempt income. How can you tax an exempt income?
The power to levy tax on that. But since we have not claimed in the return,
I think it's a very fit case. When you go for a appellate authority, I think you should get relief at the CIT level itself, which is generally you won't see. But this is such a clear case where it is an exempt income. He cannot ideally tax it.
Sir, in the case of, say I have forgotten to claim depreciation or an additional depreciation, can he actually say I cannot give you that because explanation 5 to section 32 says it's mandatory.
Correct.
Can he still go say will apply or?
So it's technically a fresh claim, but
we can go for 154 hours.
Apparent on the face of
It
it.
is a mistake apparent on the record.
mistake of what? It's,
It is very clear under section 32, difference shall be allowed whether it is claimed or not. by
no,
the
that you are right, but he is talking when the matter is pending with the AO.
Yeah,
It is still pending.
still pending with the AO.
Still pending means it is mandatory, he has to allow.
He has to still allow, that's what I'm saying.
So the best thing is, which practically may not be possible, I'm not sure in your case whether time limit for revised return is available,
Yeah,
which
assuming
most
it's
likely
gone,
won't be.
Assuming it's gone.
So
Still explanation 5 so specific in that case.
ideally it should allow. If it doesn't allow, then the next solution, it's in the appeal it should be allowed. Because it's a very, very minor mistake done by the assessee. Yeah, so sorry, so I move to the next slide. Assessment of a non-existent company. So for an example, there a company X gets merged into company Y. Can assessing officer still do assessment of company X after the merger? The answer is no, it will be a nullity. Even if you want to assess the income of company X, he has to do it in the hands of company Y. Now,
It can be done in the hands of the directors in case of a struck off company. The company which is struck off.
Understood, 248 you are saying. Something like under the companies that you are saying, you have got the,
Right.
yeah, so,
Income tax department also sleeping ready to look at the ROC website and it gets struck off.
so if that is the case, and whether it can be done in the hands of the directors, I think he can do a protective assessment here to safeguard the interest of the revenue. But you should also understand whether it is a privately held company or it's a public company. If it's a privately held company, then the situation of getting assessment in the hands of director will be more, because there will be very few people who will be handing over those companies. But practically I have not seen that situation happening. So have you seen that situation?
No, we have not, but it will drop out now because lot of activity.
Correct, you are right. So
pending assessment are being.
right. So there is, as you rightly told, lot of
Lot of companies have huge creditors
Hmm.
which have been not, I mean, all unexplained creditors. Some cases have been pending, but then have been struck off.
correct, correct. So generally for struck off, there has to be a nil business in the company
Right.
for 2 years, if I'm not wrong, and there should not be any asset or liability.
Right.
So in your case, if you are saying there is some liability, I'm not sure whether they can be struck off in the first
No,
place.
the ROC is striking it off.
Still are striking
because
off.
they have not filed their ROC returns.
Non-compliances,
That one issue will crop up now.
Possible.
Last-
very much possible. So moving to next, contents of assessment order. So what all things should be there in the assessment order? One is your computation, tax computation, which is ITNS form, part of the assessment order. Other is your 156 notice, which is your tax demand notice, and computation of income. And the last, which should be there as part of your assessment order, is if the assessing officer wants to initiate penalty proceeding, he should record his satisfaction that penalty proceeding should be initiated. So if all these things are there, you can say the assessment order is a complete order. If he does not record penalty, he cannot initiate penalty also. So that is a different point. Rest all computation, tax demand notice, even if it is a nil tax demand, zero tax demand, it has to be there as the part of the order. Otherwise, the order is incomplete.
If they recorded penalty proceedings, what is the time limit?
For
Assessing officer recorded a penalty proceeding will be initiated
6 months.
In this situation, what is the time limit to initiate the penalty?
6 months, I believe. Sir.
So initiation is 6 months, but completion there is no time limit, because generally you will go for an appeal. So the period up to your appeal will get excluded, and once the assuming you get certainty at an ITET level and the order is against you, then the penalty or proceedings will be again commencing, or otherwise if you get complete relief it will be dropped. So time period wise it remains open. Exactly number of months I need to see, because the penalty proceedings I am not covering here as of now, so please pardon me for that. E-assessment. So most of us would have by now seen this concept of e-assessment, and recently there has been an instruction issued by the CBDT, instruction number 1 of 2018, which was issued in the month of February 2018, which gives the detailed kind of law around e-assessment as to how the assessment will be done. This is the background. So the background is in 2015 October, some pilot project basis e-assessment were started in 7 cities of India, which is mentioned on the slide. And while still e-assessment is voluntary choice, one can still opt out of it. This time it was started on a pilot project basis, so certainly it was not law. It was only voluntary for the assessee to comply. CBDT notified the procedures for transmission of electronic notice, which is by way of amendment to section 282, which I touched upon. Section 223C also, the meaning of hearing was amended in the Income Tax Act to give effect to the e-assessment, which includes communication of data and documents through electronic mode. And then instruction number 8 2017 was introduced to provide a platform through which the communication will happen under e-assessment. So this is the kind of background about e-assessment. And recently Finance Act 2018 has amended section 143 by inserting 143 3A to 3C, mentioning about the procedures to be followed during the time of e-assessment. So this was the instruction which I was telling. So it clearly lays down what all would be the rights of the assessee, how the proceedings will happen. So to discuss a few, all cases under e-proceedings except search cases or where the assessee objects So all the proceedings under the Act will happen through e-assessment mode, except such cases or where the assessee wants to opt out of e-assessment. Otherwise, everything will be done through e-assessment. All notices and orders to be digitally signed by the AO, online submissions to be filed, and it has to be filed within the office hours. So one should not understand, okay, it's an online submission, I can do it late in the night also. The system will not allow you. The facility for electronic submissions will be automatically closed 7 days before the time barring date. So one should understand that you cannot approach the assessing officer at the fag end of December through your assessment procedure. In some situations, assessing officer may extend the date for filing, and the filings may happen within those 7 days also. So that's the first slide. I'm moving to the next. So the instruction also has some provisions to allow manual assessment even if the assessee wishes to go for e-assessment. So where some manual books of accounts has to be presented before the assessing officer, then a manual hearing may be allowed. AO has invoked 133.1, he has gathered some notices from third parties, information from third parties, and he has to give opportunity to the assessee to cross to see those information or to file counter. That situation again, there can be a manual assessment, and if assessing officer wants to convey prima facie opinion about a particular transaction, he may still convey those ideas or conveys those opinions to a assessee and allow him to come and explain in detail in a manual manner. So these are the exceptions carved out where even under e-assessment mode the hearings can happen in a physical form.
The showcase note is mandatory before assessment and re-assessment.
In a sorry.
In the e-assessment, the showcase notice is mandatory because in normal we don't practically do it except for the
So cause, so certainly so cause will be there, right? Because if e-assessment is going on, notice will be for gathering information, you are saying, right? So like a 142.1 notice. So still you will be getting a 142.1 notice itself. Just the mode, sorry if I'm not.
No, I'm asking something like a draft order, like transfer pricing.
Yeah, so
In personal thing, at least I can talk what is it he's thinking of, what is it he's going to.
Absolutely.
Here there is no communication. Probably suddenly bolt from the blue he passes.
So that's the downside of this e-assessment, which I will discuss. So the good side of it is their interface is reduced, the transparency will increase, things will be there in the platform. Everything will be available on the platform and nobody can work around it. But the downside is if you think there is something which requires a lot of discussion and debate, you may not be able to do that.
At least a draft order would have been provided.
So, so you mean to say in a normal, it's not a 144C assessment, still a draft of the order should be,
Yeah, so then I can reply, he can conclude at least,
So I think what you are expecting is more of a comfort with your officer. Sometimes he may show you the draft order before passing it, but there is no express law even under manual proceedings that he should show you the draft order.
Yeah, at least we know what are the points they're agreeing on or
Correct.
where we envisage a.
we can record.
You are right. So that is certainly a lacuna, and if the officer his jurisdiction, he may still entertain you on a one basis, but technically that provision is not there that he has to show you the draft of the order before passing it. So
Transfer pricing it is there.
so transfer pricing is when you are talking about transfer pricing, it is a 144C assessment you are saying.
Yeah.
So 144C assessment, the law itself provides that he has to pass a draft order.
The same can be extended. I'm just talking about.
Okay, so yeah, so if
Almost.
in the benefit of assessee, yes, it can be done.
Almost last year, all the e-assessments were like the assessing officers manually converted into a physical because they said no. They asked the assessees to send a mail asking them to convert into a
Manual form.
manual.
So, it's a simple thing, it's a change, and everybody is not flexible around the change. So especially the tax officers who are not so conversant with the technology. So we have teams who can help us out and do it. They are more handicapped, I'll say. So that is the reason they sometimes ask us to do it informally. Any practical experience anybody want to share? Okay. We'll move to transfer pricing assessment. So reference to TP officer. So now this is more or less settled now by way of instruction number 3 of 2016. Which says if the assessing officer has to make a transfer pricing adjustment, he has to refer the case under 192 CA 1 to the TP officer. So this is settled. TP assessment without regular assessment. Can there be a TP assessment or a reference to transfer pricing officer without any assessment in place? The answer is no, because reference has to be made during the course of assessment. It can't just be a transfer pricing officer doing his own assessment. Transitions not referred to by AO. So if the transition is not referred, so assuming transfer pricing officer asks the TPO, AO asks the TPO to see a transaction with party Y, and TPO believes the transaction with party X also may be subject to transfer pricing, and there may be some arm's length issues around it. But if he wants to see those transactions, the section now itself gives a power to the transfer pricing officer. There was an amendment in 2012, so which puts this issue at rest. Determination of ALP by AO, we already discussed. Instruction number 3 requires AO to compulsorily refer the case to TPO. If you don't want to refer, and in that case there cannot be any transfer pricing adjustment. But if he wants to have transfer pricing adjustment, he has to refer to the TPO. Assessment order pursuant to TP order. So this is simple. AO has to follow what is there in the TP order, and he has to pass the assessment order accordingly.
Whether it is binding in nature, the findings of TPO is binding on assessing officer.
It should be binding, because if he has to refer, then if there has to be a...
Is there any express provision binding the assessing officer?
So I think instruction number 3 itself will, I don't know the exact paragraph.
He is bound by, he cannot, if an addition is recommended, he has to make it. He cannot do that.
So you can go by the principles also. So if he has to do an adjustment, he has to refer to TPO. Now if after getting a order from TPO, how can he again deviate? So principally he should not. If he has to deviate, there can be an internal communication between them.
But there was one practical which I have seen, like there was an adjustment, TP adjustment, but that cannot be incorporated in the final order.
Okay.
Because there was no interest levied. That is, they had got a loan from a foreign company, parent company,
Okay.
but there was no the interest.
It was
rate
interest free.
That was like the interest. There was no interest for the
Expenditure
initial
claim.
payment. Initial payment.
Okay.
Okay, it was considered to be zero interest now, but the final after 5 years,
Understood.
subordinated debt.
Okay.
After 5 years, it was 28%. But the assessing officer said, no, as per SBI or whatever rate is, yours is 28%, now it has to be 12% this year. He gave some number, but the interest debited was zero. So there cannot, though the transfer pricing order had a number of, instead of zero, it had some number, but that order, TPO order cannot be put into effect because as it is, the interest was zero. I cannot.
So the objective of transfer pricing is to increase the income.
But
In your situation, if he is to impute 12% interest on a
Then
loan
the-
taken from outside India, it will add to the expenses.
Yes, so-
That goes beyond the intent.
So we argued before the AO also saying that you cannot incorporate, that TP order cannot be incorporated here because if you are going to put that interest, we have already debited zero, so you cannot put that interest. It's not like we have debited 20, you are asking us to say it's 6 or 5. It is zero, then you cannot do that.
Correct.
So in that case it was practically what happened.
Correct.
I didn't follow actually. What had happened? I mean, there is a debit.
It's a subordinated debt. So initial 5 years there was no interest at all payable to the company which has lent the money for the foreign company. After 6th year, your interest will be 28% or 12, whatever, higher interest. But what the TP officer said was 28% is high, so you should have paid 12%. So the interest is 12%, not 28%. He had calculated some SBI rate and all. So he said without any interest being debited in the book, he said, say you have 100 million loan, so into 28% you have said it is 28 lakhs or whatever, it should have been 12 lakhs, so I am disallowing 16 lakhs, for example. So when there is nothing, the books had not debited any amount at all, no expenditure at all, because I am in the first 5 years. The interest debited was zero because of the subordinated debt. So where can I incorporate the 12 lakhs differential in my...
TP TPO job is to only determine
Between
the
the
value of the transaction.
transaction. That may not actually, since the transaction was not existent in this particular year, that cannot be.
Correct. So I think what you concluded on the transition is the correct answer. He cannot increase the expenses. Maybe he didn't understood the law properly.
Binding will take place.
Sorry.
How come binding will take place?
Binding, but tax is violating the law itself.
Then if
It
I
is
do
really
that,
That's
then
what I'm saying. No, his question is just a recommendation.
Given like
No, so AO himself will not agree to what he is doing now. Here the point is, it is beneficial to the assessee.
When he's referring, he's just recommending that you can go with it, but it can't be a binding.
It is very
It
much
is
binding.
recommended in nature.
See,
Yeah,
this
no, it is
particular
not
case,
recommended.
against the provision.
it's against the provision.
Right.
And you
Against
do
the
three
provision.
counts.
It's against the provision. So what he is doing is not legal.
Exactly.
So what he has to do should be legal and then it becomes binding.
Then we had to convince the assessing officer that you cannot incorporate that order in
No,
your order.
if the assessing officer wants to incorporate, it is good for the assessee. There can be other challenges, but you can't say, no, you have not withheld taxes on a notional expenditure. So those things are separate.
They haven't claimed.
As far as,
They have not claimed, it is disallowance. What they are speaking is disallowance. An expenditure which is not claimed has been disallowed. That is the case. It will increase for total income.
Something is not happening.
So assessing officer finally, he asked us to explain, we explained, he said no, he didn't make any additions, whatever TP said, he just left it there. So we didn't, it was not also challenged before the DRP or anything, because since the final order did not have this addition, so we didn't feel, the assessee didn't feel like challenging him, taking that into the DRP, because he said, let me see after 5 years if it's really going to make profit and I'm going to pay the interest. So it was a call assessee made. But this was one situation where there was an addition as per the TP order, but it was not incorporated, where it was not able to be incorporated in the.
so when you are saying addition to expenses or addition to
It was
income?
that was not clear in the
Okay.
TP order itself.
Correct.
It just said the arm's length price is not 28%, it is 12%.
So here they have determined the amount to be disallowed.
Amount to be disallowed which was not there.
Yeah, yeah.
So if we math
He took the loan in the entirety and the interest in the entirety for the tenure of the loan and said this should have been.
Correct. So what is going to happen after 5 years, he preponed it.
But we have to see whether it's a violation of accounting standards to make a corresponding provision of a matching concept. See, the interest may be, so it should be split off over the period of years.
Actual interest,
Ah.
if they would
So
have provided,
probably-
then they would have taken account of it.
So there may be accounting angle also, because if you are saying there was a moratorium period of 5 years, nothing was paid, and after it was paid, how an auditor will see
Probably
it?
it was not, it was prior to all the the recent thing, but the one which I practically saw, I handled that. So
That was interesting.
Suppose if there is an interest-free income, suppose interest-free loan is given, then suppose he is imputing interest, then that can be added.
Yeah.
Correct, because in income.
Yeah.
So if it is an income, he can certainly add. He is supposed to do his job of adding
if it is
income.
X, you can say X plus Y, but here there is nothing to.
price cannot be used to reduce the
Reduce
tax
the
rate.
Correct. That's what I was.
Transfer pricing provision is very clear when it, 9(2) itself is very clear when you have.
Correct.
If it goes on to reduce your income, then
Absolutely.
increase your costs.
So the last point is draft order versus final order. So what we consider as draft order and what is the difference between the two? So if I have to put it simple, order with a 156 notice of tax demand, it may be zero or it may be of some positive amount or a negative amount or refund, it becomes a final order. What if a situation where a draft order is passed with a 156 notice, whether it will be considered as draft order or final order? So
Draft
No, you can't.
No, it has to be considered as a final order. A draft order cannot be accompanied with the demand and a
absolutely right. So it was a final order, effectively. Assessee challenged it that
No draft order.
yeah, so I have not been given a draft order, so I have been denied that right, and hence this order is not maintainable. And it was ruled by Madras High Court in favor of the assessee. In case of, I'll tell you the name of the judgment. Yes. So in that judgment, sorry, who answered that question? Which? Acha, you know that judgment. Yeah, so in that judgment it was held in favor, saying that a draft order with the demand notice is effectively a null and void order. Moving to next, application before DRP. So we all know the provisions got inserted by Finance Act 2009. The objective was for faster litigation resolution, so that the SSE need not wait to get a resolution from CIT appeals where the matter is pending in large number, and then you have to approach tribunal, which will take you at least 6 to 7 years. Here, through the DRP mechanism, you reach to tribunal level within 3 to 4 years. So that way it is a very faster route. The other benefits of going to DRP is your demand does not get crystallized till the time the final order is passed. So you have that cushion of 1.5 year where you don't need to pay taxes immediately. So that is the other benefit of going to DRP. Of late, we see all negative orders coming from DRP. Correct. So this is bound to be there because of the amendment which says department.
Order is binding.
Correct. So it is binding on the department. So they cannot challenge it before ITAT, and hence DRP is extended arm of the department. Eligible SSE. There are the two categories of eligible SSE. One is where there has been a transfer pricing adjustment. Other is a foreign company or foreign SSE. So these are the only two eligible SSEs for whom the applications of provisions of DRP will apply. DRP direction is binding on AO, need not give opportunity to SSE. So what do we understand from this? So it's like you approach DRP, DRP has issued the directions. Now if you think that AO should again give you an opportunity before applying the directions of the DRP, which is incorrect. It is not required. Once the DRP directions are issued, AO has to follow those directions and pass the final order. So he need not again give you an opportunity for hearing after the DRP directions. Can DRP consider issues not covered in the draft order? This is interesting. So what can DRP enhance, if I have to ask? Okay, if it can enhance, then is this power very open? If nothing is coming from the draft order, still you can bring in one more additions in the draft order. So I have to ask you, there was some expenditure which DRP believes should not be allowed under section 37. That was never challenged by the AO. Can DRP do it suo motu? So the correct answer is no, but the way we need to see regulation is DRP can do any addition which has come on account of variation from the transfer pricing adjustment. So he can touch on the variations. Now, to increase the power of DRP, there was an amendment done in section 144C. I'll just read it out. So, subsection 8 explanation. For the removal of doubts, it is hereby declared that the power of a DRP panel to enhance the variation shall include and shall be deemed always to have included the power to consider any matter arising out of the assessment proceedings relating to the draft order, notwithstanding that such matter was raised or not by the eligible SSE. So this amendment or the explanation was inserted by Finance Act 2012, increasing the powers of DRP, but still it has to be read in the context of dispute resolution panel to enhance the variation. It means there has to be variation in the first place. So variation means if the officer says disallowance should be 30, DRP believe it should be 50, it can be done. But DRP cannot still bring a fresh addition even after the insertion of explanation. That has been the views of some of the practicing chartered accountants. So I think I've answered the fourth question. Can DRP consider issues not covered in draft order? The answer can still be no. Can be debatable, but one can take a position. Final order passed by AO pursuant to DRP directions. Revision under section 263 possible is the question. So since what is revision under section 263? It is a suo motu revision by the CIT. So since the DRP panel consists of 3 CITs, another CIT cannot review it against under 263. So the answer will be no. Final order passed by the AO pursuant to DRP directions appealable before ITET. It's no-brainer as of now. Whether penalty orders, withholding tax orders can be referred to DRP. So if a foreign company has got withholding tax order, like a Vodafone deal, assume. So whether he can approach DRP? The answer should be no, because if we read section 144C1, at the fag end of subsection 1 it says any variation in the income or loss returned which is prejudicial to the interest of such assessee. So penalty and TDS is not income or loss, and hence for this matters one cannot approach DRP. Directions against the department remedy. Department now cannot file an appeal against the order of DRP. So department does not have a remedy under that, but a writ can still be explored. Can DRP set aside or direct further inquiry? So power of DRP to set aside is not there, because DRP's power is generally akin to CIT appeals. CIT appeals cannot set aside the assessment, so does DRP. DRP can ask the assessing officer to give a report on the assessment and accordingly make the adjustments. Withdrawal of DRP application. Can after filing application, one can withdraw the application from DRP? So the answer here can be no, because there is no explicit power given to DRP for withdrawal of application. Similarly, if DRP can condone the delay in filing application, whether if there is a delay in filing application, can DRP condone it? The answer can again be no, because there is no provision under the 144C to allow DRP this power.
And there is no specific provision I can approach the High Court and get for the condemnation.
Correct. So that is different, but DRP itself cannot. Yes.
For CIT appeals, is there power? I mean, to condemn?
CIT appeals power to.
Yes.
That they normally we find condemnation.
They don't.
Yeah,
Is there a specific
they have.
provision?
CIT appeals, I have not covered it here, so I need to look at it, but I believe it is possible.
It's not inherent power. Person who is adjudicating has the power to condemn.
Okay, so in that case you are saying DRP can also condone the delay. Okay, so this has been,
Quasi-judicial authorities all have the chance.
okay. Is it a power of a court?
It's quasi-judicial power of the court.
Okay. Practically I have not seen it. Maybe if you would have endured some cases, anyone here, where a delay has been allowed by DRP, delayed application.
In fact, the tribunal today they did not accept a plea like that. It happened in the tribunal.
Okay. So maybe the reasons were communicated for delay and still they were not convinced.
I don't know because my senior appeared. But
Okay.
what he was saying is that they were not ready. The bench member said that since the DRP is not condoned, what power do I have to look at it?
Yeah. So that's it for DRP. Now the assessment under GAR. How does assessment will happen under GAR provisions? This is codified under section 144BA of the Income Tax Act. So effectively it is not in the chapter covering the GAR provisions, it is outside the chapter. So there are 3 parties in this transaction. One is the tax officer, the other is the commissioner, and the last is the approving panel. So assessing officer himself cannot issue a notice to the assessee to initiate GAR proceedings. That is the first thing. He has to communicate it to the commissioner saying that he wants to initiate GAR proceedings. And once the matter is communicated, commissioner has to issue a notice to the taxpayer seeking reasons why GAR cannot be applied. Taxpayer has to give objection within 60 days of the receipt of the notice. An opportunity will be given to the taxpayer of being heard. So 60 days clear timeline has to be given to response back to the notice. If Commissioner is satisfied after the assessee's rebuttal that no GAR should be applied, no GAR provisions are not attracted, proceedings will be dropped in the first place. Else, the matter will be referred to the approving panel. So approving panel, till now it has not been constituted. We are still awaiting the notifications for that. So if assuming it is constituted, the approving panel will then again hear the case with the assessee. The assessee will be granted opportunity of being heard. And once approving panel is convinced that GAR provision should apply, they will pass an order. And the remedy against that order would be to file an appeal with the tribunal. So order confirming the applicability of GAR can be passed only by the approving panel. Till Commissioner, the order won't be passed. It will be just a reference back to the approving panel. Now, to relate it back to the AR application, section 245N, once the transaction is done, you cannot then file an application for getting a ruling on GAR. But assuming the transaction was not done and you have already filed an application with the AAR, you can apply the benefit of 245RR if you are a resident applicant, and that transaction cannot be then challenged till the disposal of the AR order. Yeah. So then you will have some relief from GAR provisions at least till the disposal of your application. Best judgment, I think theoretically we all know what is best judgment. If you don't comply with the 142.1 notice, you may have best judgment. If you don't comply with 143.2, if you don't comply with the direction of a special audit under 142.2A. So these are the circumstances which triggers best judgment assessment, or when the assessing officer is not satisfied with your books of accounts. Partial compliance. So if you comply to a 142.1 notice partially, then also best judgment assessment can be done. Issue notice to assessee, record satisfaction. So notice should be issued to the assessee and satisfaction has to be recorded by the assessing officer before initiating the best judgment assessment. Return file after 144. Excuse me. And this is some typo error. I think there is something missing in that line. You can ignore it for the time being. Moving to rectification. So we all know rectification can be done only when there is a mistake apparent from record. If there is anything debatable, 154 cannot be done, which is the rectification section. This principle had been laid by Supreme Court in the case of T.S. Balram versus Volkat Brothers. So amending order should be passed by such authority. So if you want to seek a rectification before assessing officer, the order should belong to assessing officer. So AO cannot rectify an order of CIT appeals or for that matter tribunal. So in fact you can also approach tribunal if there is an error in the order passed by tribunal. Your section number will be different, but again you have to prove that there is a mistake apparent from record. Mistake apparent from record can mean different things at different forums. So when it comes to tribunal, non-application of an order of a high court or jurisdictional high court or Supreme Court can amount to mistake apparent from record for tribunal. When it comes to AO, still it may, the law can be applied in a similar manner, but AO may always debate on that, saying, this is, he don't agree with the position. So AO can still debate on it, and hence it may not be a rectifiable order if you bring a judgment of a High Court or Supreme Court. So what he can rectify is some clerical errors, some mistakes which are in the computation of total income, some deductions which he has not granted. Those things can be taken up before the assessing officer. Amending any intimation which we have already discussed, 143(1) can be subject to 154 if there is any mistake. Online rectification of the application. So now you have an option to do a rectification through the e-filing portal, where you will have an option in a particular tab. I'll just tell you the tab which has to be seen for rectification. Rectification request. If you go to that tab, you can put the reasons for the rectification and make the necessary correction. Doctrine of merger, which says once a rectification is done, the rectified order merges with the original order. So 154 always has to be seen with the main order which has been rectified. So these are the various timelines. So as we all know,
Appeal is required for 154 order again.
so if 154 order is adverse to you and you believe you need to file an appeal, that's what you're asking, right?
Against original order, we have filed an appeal. And we also filed 154 rectification order. In the rectification order, certain points are missing. In such situation, shall we go for additional grounds on the original order, or shall we file once again 154 appeal against 154?
So I think practically what as a assessee you would have done is, if you find some mistake in the order and you know you are going for appeal, you will not leave those grounds for appeal and just put a rectification for it. So you will try to cover it both ways. You will file a 154 as well as you will cover it in appeal. Assuming you have not done it, you thought it is very much clear that 154 can be done and never filed, you didn't took that ground at all. If the appeal is pending, you can bring those ground as an additional ground, saying that you had a genuine belief that 154 was possible, and since 154 is not being done by the assessing officer, he has denied that opportunity, you can add to those grounds. Now assuming your appeal is not pending at all and 154 is not done, when he passes a negative order, I believe that you would have missed your opportunity here, because if it merges with the original order, your time limit as well as your order is already decided. But as an assessee, you can still try and file an appeal, but the situation will be different. The best thing possible is to put this as a ground of appeal also, and also file the rectification, so that you don't lose that opportunity.
Has this been settled, this point you are saying, 154 order get made, so I lose the time? Has it been settled or still such?
I think it is a settled issue. It's a settled issue because 154 is nothing but a rectification of the original order, and it has to be done by the same officer. So it has to relate back to the original order. I think the judgment you can refer here is Hindu Wires, where they have discussed at length about the merger, doctrine of merger. I'm not sure whether it is in the context of 154, but the doctrine of merger has been well discussed in that judgment. Time limit for making an assessment, currently it is 21 months up to assessment year 17-18. Going forward from 18-19, for 18-19 rather it will be 18 months, and 19-20 onwards it will get reduced to 12 months. So this will mean very quicker assessment. In fact, its assessment time period is as good as a 143(1) intimation time period. So from AY 19-20 onwards. Time limit for making assessment, reassessment or recomputation, currently it is 9 months from the end of the financial year. This has been increased, and from AY 18-19 onwards it will be 12 months. So this is
Return period or proceedings period?
this is for the return.
Return. Suppose there is assessment year 17-18, return scrutiny is going on, then they will be getting 21.
Correct. Best practices, we should see the notice, check the jurisdiction, validity period, avoid lengthy submissions, rely on the case laws wherever there are binding judgments. We should carefully read order sheet notings and maintain details of date-wise information, submissions and representations made before the AO. So these are the best practices one should follow at the time of assessment. I think with this I conclude the discussions. If there are any other questions, please feel free to ask.
What is the concept of the protective assessment and whether any pre-deposit is prepared?
Protective assessment where, generally it happens where for a shipping company, I can say, or whether there is a partnership and partnership is being closed down. So those are the situation where the assessing officer will travel beyond the entity and try to do assessment in the hands of somebody else, so that the interest of revenue is protected. So these are the practical situations. Now, may I know your exact query on that?
My query is now the assessment is paused as an protective assessment.
Okay.
Demand notice also served.
Okay.
In this case, is there any requirement to go and file statement?
The first thing.
Why? Because the assessment order passes protective assessment only. To which extent they can go? They can go even up to the level of prosecution.
So
But
you.
the assessment order they are simply mentioning that it is a protective additions.
So first thing is you will challenge it, saying that I am not the representative assessee, or there is no succession as such. So those are the situations where he can do an assessment of one person in the hands of other. So if you say that I am not involved in this transaction, or I am not the beneficiary out of it, then the protective assessment cannot be traveled back to me. If you are able to defend that and still he goes ahead with it, you can appeal in the natural flow of the provisions, or the best possible thing here would be writ, because here you will require an immediate remedy, otherwise you will have to face the tax consequences. So
Regarding pre-deposit, is it mandatory? Is there any special provision?
not sure. I'm not sure because I have not handled any protective assessment as such. So I think it will depend on the relationship with the tax officer also. If he is thinking that the objective is to do protective assessment, means he is assuming that taxes may not be paid. So he may ask you a guarantee for sure, or maybe pre-deposit amount which you are saying. If the remedy to a pre-deposit amount can be a guarantee here, which assessing officers would also get convinced. Any other question?
What about the power of CIT appeals to make enhancements? Can he make any enhancement? Because it is just extension of assessment proceedings. On that basis, can you just with the principle that you spoke of with respect to DRP will get applied to CIT?
See, ideally, power is there to CIT appeals, but there is one judgment in the case of Sapojji Palonji. Maybe you can go and refer that. It says that CIT should not travel beyond his powers, and he should not act in the capacity of the assessing officer. So what can be done by the assessing officer should be done by the assessing officer. So although he has the power, but he should not use those power very often. So you can rely on that principle coming from that judgment.
This is the
Supreme Court, yes. So to answer your query, he has the power, he can do it. Any other question as such? So thank you. Thanks a lot for your patient hearing, and thanks for the interactive session also.
Good evening to all. We are happy that Nitish sir has explained and enlightened us on his advanced ruling and assessment procedure as token of gesture and presentations being made. Give a big applause.